Hello friends, welcome back to conversations adult children need to have with their parents. Today we're going to be talking about wills. You've heard me mention how important they are to have, and I'm going to relay the top 10 reasons to have a will according to findlaw.com. Every state has different laws and regulations when it comes to wills. I am not a lawyer or an expert in wills. These are reasons just to get you thinking about getting a will written if you have not done so already. Always, always, always consult an attorney in your state for the laws regarding to wills. Okay. My husband and I had our wills drawn up several years ago. What prompted us to do it was because, well, we had been procrastinating on setting up a will, was that David was going on a business trip to India. And we knew he would travel to and from just fine. But in the rare chance that something happened, we wanted to make sure our affairs were in order. If you are a parent of a child who is under the age of 18 and you don't have a will, in my opinion, you need to find a lawyer and have one drawn up ASAP. Top 10 reasons to have a will according to findlaw.com. Number 1. You decide how your estate will be distributed. A will is a legally binding document that lets you determine how you would like your estate to be handled upon your death. If you die without a will, there's no guarantee that your intended desires will be carried out. When my husband's aunt passed away a few years ago, in her will she had specific groups listed who were to get specific items from her estate. She had everything laid out in detail, which made it much easier for my mother-in-law to distribute the belongings. Number 2, if you have children under the age of 18, this is the most important reason of all. A will allows you to make an informed decision about who should take care of your minor children. Absent a will, the court will take it upon itself to choose among family members or a state-appointed guardian. In our will, we had my sister as our daughter's guardian and my husband's sister as a backup. Having a will allows you to appoint the person that you want to raise your children, or better yet, make sure it's not someone you do not want to raise your children. To avoid a lengthy probate process, reason number 3. All estates must go through the probate process with or without a will. According to the American Bar Association, probate is the formal legal process that gives recognition to a will and appoints the executor or personal representative who will administer the estate and distribute assets to the intended beneficiaries. Number 4, minimize estate taxes. Another reason to have a will is because it allows you to minimize your estate taxes. The value of what you give away to family members or charity will reduce the value of your estate when it's time to pay the taxes. Number 5, you decide who will wind up the affairs of your estate. That's the executor you've heard me mention before. Executors make sure all your affairs are in order, including paying off bills, canceling credit cards, and notifying the bank and other business establishments. Because executors play the biggest role in the administration of your estate, you'll want to be sure to appoint someone who is honest, trustworthy, and organized, which may or may not always be a family member. Number 6, you can disinherit individuals who would otherwise stand to inherit. Most people don't realize that they can disinherit individuals out of their will. Yes, you may wish to disinherit individuals who may otherwise inherit your estate if you die without a will. Because wills specifically outline how you would like your estate distributed, absent a will, your estate may end up in the wrong hands or in the hands of someone you did not intend, such as an ex-spouse with whom you've had a bitter divorce. Number 7, make gifts and donations. The ability to make gifts is a good reason to have a will because it allows your legacy to live on and reflect your personal values and interests. Please consult an attorney for the current laws on gift tax exclusions in your state. David and I have each named nonprofits in our wills to receive gifts. Number 8, Avoid greater legal challenges. If you die without a will, part or all of your estate may pass to someone you did not intend. For example, there was one case involved the estate of a deceased son who was awarded over $1 million from a wrongful death lawsuit. When the son died, the son's father, who had not been part of his son's life for over 30 years, stood to inherit the entire estate, leaving close relatives and siblings out of the picture. Reason number 9, because you can change your mind if life circumstances change. A good reason for having a will is that you can change it at any time while you're still alive. Life changes such as births, deaths, divorce can create situations where changing your will is necessary. A tip we learned from my parents and our attorney: when you name a specific person to be guardian or to receive a financial gift, only list that person's name. Do not include the spouse in case of future divorce or death. And reason number 10, because tomorrow isn't promised. Procrastination and the unwillingness to accept death as part of life are common reasons for not having a will. Sometimes the realization that wills are necessary comes too late, such as when an unexpected death or disability occurs. To avoid the added stress on families during an already emotional time, it may be wise to meet up with an estate planning lawyer to help you draw up a basic estate plan at the minimum before it's too late. Yes, please, 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 make sure your loved ones have a will and that you have one too. It is extremely important. And as I said before, you can make changes. My parents had their first will drawn up in 1985 when we moved into the house my dad still lives in today. They wanted to protect the house and my sister and I if they were to pass unexpectedly, before we turned 18. So my parents named a guardian for us and what should happen to the house in the event of both of their deaths. Well, that will was still intact 30 years later. In 2017, 2018, they worked with an attorney and got the will updated. And it was then that I learned my parents chose me to be their executor and power of attorney. Well, friends, I hope this was helpful to you and gave you food for thought. Next time, we're going to talk about power of attorney. I hope you and your family are well. Take care until next time. TTFN. Ta-ta for now.